Supreme Court of India Nanhe vs. State of UP decided on November 21, 2023 SCC Online SC 1491 Facts of the case, on May 30, 2007 at about 3:30 p.m. Mahendra and Nanhe, appellant, quarreling with each other. Sant Ram, the brother of Mahendra, intervened and asked Nanhe, appellant, to leave the place. On this, Nanhe, appellant, left, but after walking 15 to 20 steps from there, he turned around and with his country-made pistol fired a shot which, piercing the neck of the deceased, hit the head of Mahendra and Saddam. Later on, Saddam was died in the hospital. 2 cases are registered. In both cases the trial court held the accused Nanhe to be guilty of an offense under Section 302 IPC under and Section 25 of the Arms Act and sentenced him to life imprisonment with fine judgment. An order of conviction and sentencing the accused was affirmed by the High Court. Findings of the court. There is no dispute to the fact that Saddam Hussein died of a firearm shot received in his neck and that the same was fired from the country-made pistol possessed by the appellant Nanhe. The weapon of offense and the cartridges were recovered from him. It is also an admitted position as established from the evidence on record that the single shot fired from the said country-made pistol after hitting and piercing the deceased in his neck had finally hit Mahendra in his head, with whom he was having an altercation a few minutes earlier. The informant, Mohammed Ali, PW1, in his deposition/cross-examination has accepted that at the time of the incident, the appellant, Nanhe, was drunk and was in a state of intoxication. SI. PW6 was of the opinion that the accused was heavily intoxicated and he was unable to speak, but the fact remains that even in such a situation he was able to walk properly and had gone 15 to 20 steps away from the place of quarrel after it was settled to return and fire. This sufficiently proves that he was mentally alert and was not incapacitated from knowing what he is doing and what would be its consequences. It stands duly established that the appellant had fired the shot in the state of intoxication which resulted in the killing of Saddam Hussein, but there is no evidence to prove that on account of the intoxication, he was incapacitated to know and understand his actions. The firing, which probably took place as a result of the above quarrel, the target was Mahendra, but unfortunately, Saddam was killed. The aforesaid killing of the Saddam was apparently not intentional and was rather by way of an accident. There is no iota of evidence to establish that due to intoxication he was incapable of knowing the nature of his act, or that the act which he was doing or likely to do was so dangerous so as to cause death of any person. Thus, in the absence of such evidence, coupled with the fact that it is not the case of the appellant that he was administered intoxication without his knowledge or against his will, the provision of Section 86 IPC would not be applicable and he would not be entitled to reduction of sentence from 302 IPC to 1 falling under Part 2 of Section 304 IPC. The appeal is devoid of merit and is accordingly dismissed.